but it's a treat to be here. It's been a treat for me to be in the Triangle area with all the researchers at 3 incredible universities all near each other. And there's a lot going on in this area and in North Carolina that provides really important opportunities for researchers to study changes and to really hopefully make North Carolina more of a model for how to do criminal justice right. So I'm going to talk to you today about 3 areas of research that I'm working on. It's not normal, particularly for law professors, to work with scientists or to have a lab, but when I came to Duke, I started a new lab, and we have 2 scientists, both psychologists, working full-time on projects. I'm working with a number of doctors at the medical school in the psychiatry department, the psychiatry behavioral health department, working with folks in public policy. And although I haven't been here long, it's been a wonderful experience working with this team of people. I also continue to work with some of my colleagues in statistics and in psychiatry at the University of Virginia. So I'm going to talk about 3 areas of research. First, relating to accuracy, second, risk, and third, needs. On the topic of accuracy, I do work on wrongful convictions. Even when I was first a lawyer, I represented people who had been exonerated by DNA testing, but who'd been convicted in the first place based on sometimes eyewitness errors, sometimes faulty forensics. Although DNA set them free, faulty forensics sent them to prison in the first place. I represented a number of people who had falsely confessed to crimes that they didn't commit. And when I became a law professor, I started researching the causes of those wrongful convictions and also doing research with scientists to figure out how to collect evidence in a more accurate way. Second, on risk, what I mean is risk assessment. How can we identify offenders that are low risk, that don't need to be incarcerated to have good outcomes? And how can we identify offenders that are higher risk and need to be subject to longer periods of incarceration, or who need treatment and could benefit from treatment because their risks could be addressed, and which is the third topic, needs. How do we focus on what kind of treatment or rehabilitative needs people have? The vast bulk of people who are in jail or prison eventually get out, and then what? There's much more focus now on reentry and what happens when people get out of prison, and also on the other collateral consequences, fines and fees, for example, that get imposed through the criminal justice system on people who are not put in jail for any particular reason, but where criminal justice outcomes can make it hard for people to keep their jobs, to get to work, to get health care, to keep their family together. So that's broadly speaking 3 of the areas that I'm working on with these different interdisciplinary groups of scientists and researchers. Some of these projects also involve collaborating with the government. We're working with a crime lab or starting new projects that may come together with the courts in North Carolina and with prosecutors. This is just an example of one of our reports. It's the only example of one of our reports that's come out so far. Our first report came out just a couple of weeks ago, and what we were looking at was juvenile life without parole in North Carolina. So no sentence can be longer than a juvenile life without parole sentence because only a juvenile can serve quite so many years. If an adult is sentenced to life without parole, there are just fewer years for that person to be in prison. And this report, there's been some news coverage of it, maybe you've come across it here and there. We looked at the cases of the 94 people sentenced to life without parole as juveniles, and we're looking at how these sentences have faded over time. There have been very, very few of them imposed in the last decade, just a handful. Almost all of them were imposed in the late 90s when there was a scare across the country involving, people were worried that there were going to be these juvenile super predators, that juvenile murders were going to skyrocket. Instead, right around 94 was actually when murder rates started to decline across the country. We don't know exactly why, but murder rates have continued to decline just about every year since. But what we also found was that many of these people who received the worst sentence a juvenile can get were not what you would typically think of as the worst of the worst offenders. Now, they were all convicted of first-degree homicide, and that's as bad as it gets, sort of the death penalty, the sort of capital murder. But about a third of these juveniles were sentenced under a felony murder theory. So some of them weren't even the person; they weren't the ones who had the gun or pulled the trigger. They were really, felony accomplices. That's no longer permitted under the law in North Carolina. But for 3 dozen people, that's how they were sentenced to life without parole initially, and it's taken years and years to unwind those sentences. And so what we also talk about is how, every single one of these sentences that has come up through the hearing process has been reversed to something short of life without parole, life with parole, or a term of years. But about half of these cases haven't yet come up for their hearings. The litigation process is incredibly slow. Some of these cases have had 2-3 rounds of appeals, 2-3 rounds of extensive hearings with all sorts of experts. So there's a question, do we want to spend millions of dollars litigating the rest of these things, or think about a different system for handling long sentences for juveniles? So that's our first report. I'll tell you about our next report coming out next month, a little bit later. So my first book, Convicting the Innocent, looked at cases of people who had been exonerated by post-conviction DNA testing. And there have been several of those cases in North Carolina. There have been several in Virginia. There have been DNA exonerations in almost every state in the United States. There have been 360 DNA exonerations and counting. These exonerations occur every month or so. There are fewer of these DNA exonerations because almost all of them are cases that involved convictions in the 80s and 90s before DNA testing was routine at the time of trial, and then it often took 15, 20 years to get the DNA test and exonerate the person. But the window is closing. There are fewer and fewer old cases where there's evidence that's still available to test. And so, most jurisdictions didn't save evidence in the 1980s, 90s after a criminal trial. And so there are, entire counties, cities where just nothing was saved. Someone says they're innocent, but you certainly can't do any DNA testing. There's nothing to test. So the cases where the evidence was saved, and it's an old enough case that it's just not done before a trial, they're just fewer and fewer of those. What we have from these cases is a unique opportunity with these hundreds of cases to study what can go wrong in a large group of cases where innocence isn't contested. There are many other exonerations that aren't based on DNA, and some of those are clear innocence cases too. Some aren't. There are cases where the murder victim shows up alive. A murder didn't happen. You can have really clear innocence cases without DNA, but the DNA cases, and there are also DNA cases where it may not be clear what the DNA evidence means. These cases focus on a more defined list of exonerations. One of the DNA exonerees in such a case, many of these cases were sexual assault cases where you can isolate the male contributor and test that DNA, and you can say, okay, the male rapist or murderer or both is not this guy, and there was one person who had done it. One of those people is Keith Harward. I singled out an image of him because he's coming to Duke for an event that I'm hosting in just a couple of weeks. His portion of it, there'll be a lunchtime event open to the public. And the way things work at law school is you don't get an audience like this unless there's free food. So it'll be just like this, but a bigger room with sandwiches. So Keith, the guy in the beard there, he spent 34 years in prison in Virginia for a murder, a rape and a murder, near the Navy base in Norfolk. And he was one of the sailors on a nuclear carrier, the USS Carl Vinson. And when the woman was assaulted, the assailant beat the husband. He goes in the apartment. The husband is there, beats him to death with a crowbar, rapes her, and bites her legs repeatedly. And they actually took dental molds of everyone on the nuclear aircraft carrier. This is 1982. It was like the biggest dental dragnet in history. They took almost 3,000 dental molds, and they compared everyone on the ship, and no one matches the bite marks on the victim. Now, the science of bite mark comparison was highly untested. There was a lot of notoriety surrounding it during the Ted Bundy case when it featured in his conviction. But actually, the dentist that testified in the very first California case where this was used in the 70s said, you know what, in our case, there's really unusual degree of markings because of the material that the person bit, but you would not normally rely on something like a bite mark in a regular criminal case. We don't advise you ever using this. People don't bite with very many teeth. Skin isn't a good medium for preserving information. I mean, it wasn't that many years ago I had toddlers. I know what bite marks look like. They often just kind of look red. But nevertheless, the California courts let it in that case because they said, well, in this case, we have good information. And then all the other courts cited to the California case and said, oh, yes, the precedent is there. You let in bite mark evidence. And it's a nice sideline for dentists. You can get paid quite a bit to be an expert in a case. In this case, they didn't know what to do. A year later, they tested all the Navy sailors. The guy who commits this assault was wearing Navy uniform. It seemed like he was someone on the boat, but no leads until Keith Harward was in a domestic altercation with his girlfriend at the time. She's, I think, choking him. He bites her arm so that she stops choking him. Neither of them were behaving that well, but the police decided, he's a biter. And so they sent his mold again to different experts, 2 different dentists. And they said, you know what? He's the one. Even though they looked at his molds before and said he wasn't the one. He definitely wasn't. Well, now he definitely was. They said there was a very, very, very high likelihood that only his teeth could have made those marks. And he goes to prison for 34 years before DNA testing excludes him and shows that the person who actually committed this crime, who then went on to commit many other serious assaults, in fact was another Navy sailor. So they'd incorrectly convicted him. They'd incorrectly excluded the guilty guy who was right there on the boat. And all of that just highlights how unreliable forensics can send innocent people to prison, set the guilty free. He was testifying in front of the National Forensic Science Commission, calling for better standards for regulating forensics. Scientific commissions have said that some forensic disciplines, like bite mark comparisons, are so unreliable they should never be used in court. There's just no evidence suggesting they can be used with any reliability. Nevertheless, they continue to get used. The commission he testified in front of actually got disbanded by the Department of Justice just about 2 years ago. And so he will be here to talk about forensics and statistics and the need for regulation at Duke on Wednesday, March 6th. A whole different range of different forensics played a role in these DNA exoneree cases. Obviously, it's unusual to have a case where there's a bite on a victim. A lot of cases, though, involving regular blood typing, which you'd think would be fairly uncontroversial. Lots of cases involving hair comparisons. The FBI did an audit of thousands of its old hair comparison cases and found that 95% of them had misstated scientific evidence in them. Some of the other work I'm doing is looking at how the courts serve their role as gatekeepers. North Carolina is one of the states, and it's an exciting time in North Carolina, that adopted the federal rule, Rule 702, a standard that comes from a Supreme Court case called Daubert, asking that judges play a role in reviewing the reliability of forensic evidence or any other scientific evidence, and also ask how reliable was the work done in this case? How was the method applied to the facts? In a really important ruling, the Court of Appeals here in North Carolina, just in the last couple of years, decided that a fingerprint examiner had testified unreliably and should never have been allowed to take the stand because she couldn't say what she did or for how long she did it for. There was no documentation. She just said, I looked at stuff and it was a match. And they said there was other evidence of the guy's guilt. It was harmless error. But they set out an important ruling saying, look, if you have a scientist who can't say what they did, there's no documentation of what they did, couldn't say how long it took, couldn't say what was relied on, all the analyst could say was, I looked at things and when I see enough similarities, then I conclude it's a match. Well, how many is enough? What is your standard? What are the rules for conducting this? We have many, many small forensic laboratories or forensic analysts working in police departments that aren't accredited, that don't have standards, they're not following the best practices in the field. And it's true, this isn't unique to North Carolina, it's a national problem. But hopefully rulings like that can start to put pressure on the crime labs that don't already do it to carefully document their work and provide support for the kind of statements that people make in court. But I think the adoption of this rule, just in the last couple of years in North Carolina, creates a real opportunity for courts to change the way they've approached this in the past, which is just to sort of, if someone sounds like an expert and has experience, just let them in, let them say what they want. Another piece of what I'm doing is educating future lawyers on how to handle these kind of complex scientific issues in the courtroom, because it's not, people like me go to law school because we're bad at math and bad at science and not because we know anything about it. And so I work with scientists and they've helped to teach me, and working with statisticians has helped to give me some remedial statistics. But the idea is that you need to learn by doing. You can't just go to a lecture and hear someone talk about statistics. We teach a class where it's actually half practicing criminal lawyers. So we had both prosecutors and defense lawyers from around North Carolina filling in half the spots in the class, and the other half of the spots were law students. And they put a fingerprint examiner on the stand for an entire day of cross. It was a forensic scientist who then went to law school and is a lawyer and co-teaches the class with me. But she can play the role well because she was a forensic analyst. She was a DNA analyst before she went to law school. And so they do a mock trial where there's one central witness who's a fingerprint analyst, and here's one of the lawyers. They marked up the print to show to the jury how some of the markings changed, and how when you see the documentation of the work done, you can raise questions about how well the work was done. So that's another way that I'm approaching these questions. We need to train lawyers to do science better in the courtroom. We can't just publish studies. Although publishing studies is good too. Here what I did with my colleague Greg Mitchell at the University of Virginia, what we wanted to see was, it's one thing to know what the error rate is for a technique like fingerprinting. And a lot of people are shocked to find out that there is any error rate. We are told that fingerprints are like unique to us as individuals. They're almost like a metaphor for individuality. But anything that any person does or that any machine does has some kind of an error rate, and you can measure it, and you need to know what it is. There are non-trivial error rates for fingerprinting. But what's different about fingerprinting from running a test through a machine, you figure that any machine, if it's a machine that's doing drug testing, for example, it has to be calibrated. There'll be some measure of uncertainty. But the measure of uncertainty, if the machine is calibrated right, should be the same on any machine. With fingerprinting, though, it's based on the judgment and experience of the person examining the evidence. It's based on their skill. And so it's not like everyone's error rate is the same. You could have someone who's really new to it and doesn't know what they're doing. They may make errors a lot more. In fact, they're often, you don't allow them to work on complex cases. You have them do simple tasks to get up to speed on fingerprinting for their first year or two. You could also have someone who's been fingerprinting for a long, long time and is kind of burned out. When you're looking at detailed patterns all day, it's really challenging work. And sometimes you meet fingerprint examiners who've been doing it for a long time, and they're looking at their watch, and it's like, because it's not good for your eyesight, right? And so you could have people who've been doing it for a long, long time, and they're not as accurate for that reason. And you could have people at the sweet spot who are highly trained, highly experienced, and their personal error rate is extremely low. We should really pay attention to evidence that they present. Now, there's separate questions. There are also fingerprints that are easier and harder to solve as well. And so you could have the best person in the world, but it's a really challenging fingerprint where there's just not a lot of information. What we want to know, there are tests that can be given to people to find out how good they are at what they do. If you tell the jury about that, will jurors freak out and say, "Oh my God, there are errors in fingerprinting. We will never believe anything ever again," or will they factor that in? And what we found was that jurors. We did a large online jury study. We found that jurors factor it in, and that the sky doesn't fall if you disclose this information about proficiency testing. That you can test people, find out who's a better analyst, who has work to do, who needs training, and jurors are going to factor that in, and they're still, almost always going to convict, but they will give less weight to the evidence if the person performs less well on tests. So we thought that was a useful study for the community because there's a lot more openness now to thinking about how to do good proficiency testing. How do we measure how reliable the people are who are doing this hard work preparing forensic evidence for criminal cases? So I don't want to go on for too long because I want time for you all to ask questions. I'd like to talk some, though, about risk and about needs. So turning to risk assessment. There's a lot of talk these days about robot risk assessment algorithms. Is this like the Matrix, or is this another example of algorithms ruling our lives? The studies that I've done with my colleague John Monahan and some other colleagues at the University of Virginia look at a use of risk assessment to identify low-risk individuals in Virginia. And it's not a complicated machine learning black box. It's a checklist. It's like 2 pages long. It looks like anything else in the sentencing guidelines, and in fact it is in the Virginia sentencing guidelines. It's the only state that's done it that way, and Virginia has been seen as a national model for that reason. There are a lot of concerns where you have courts or judges adopting a risk assessment instrument without input from the public. In some states, like in Wisconsin, it is a black box proprietary algorithm that a company owns. And so a defendant can say, like, you're giving me a worse sentence because of an algorithm and no one can tell me what it is or what the factors are, and the judge doesn't even know. That violates my due process rights. That went up through the Wisconsin courts. A lot of us in the community who are nerdy law professors were hoping the Supreme Court would take the case since it raises really interesting issues. The Supreme Court did not take the case. But in Virginia, it's not a secret algorithm. It's a checklist. It's easy to understand. It was adopted because the lawmakers in 1994, when Virginia adopts sentencing reform and abolishes parole, they're worried, okay, we've just abolished parole. Now our prisons are going to be overwhelmed. To save cost, to divert low-risk offenders, we need to have some kind of a risk instrument. They told the Sentencing Commission to bring in scientists and develop such an instrument. They did that. It's not based on 1997 data. They've continued to revalidate it. to identify these people. They have a very high threshold of what they call low risk. It's 85 or more percent likelihood that this person will not commit any felony of any kind in Virginia or in any other state over 3 years. And they found over time that their instrument is highly predictive. And they've amended the instrument, they've changed it. It relies on some pretty simple factors. It does rely on gender, which is normally something that makes one higher risk, although for larceny, which I guess involves a lot of box store shoplifting charges, being female is a higher risk. It looks at prior criminal record. Are you imprisoned or under parole supervision at the time of the offense? And age, and not much else. What we found, though, is that judges, when they get this information, they see this worksheet, they see the points, they say, oh, well, this person is low risk. They have discretion to decide what to do. And there are a huge number of people. There's 6,000 plus felons, these low-level felons, who are eligible for the alternative sentencing under the sentencing guidelines in Virginia. What we found is most of them are not getting released. We find that 42% of the time these low-risk felons are getting alternative sentences. But the majority of the time they're not getting it. What's also interesting, though, is that 23%, a non-trivial number of the high-risk people, are getting alternative sentences. So what's going on there? Why are judges giving alternative sentences to high-risk people? And there's another group of people where the risk information just isn't filled out for some reason, often because the case is plea bargained, and plenty of them get alternative sentences too. And so they're not even looking at the risk instrument, but giving alternative sentences. So none of this seemed ideal, and we wanted to dig into this more to figure out what's going on. What we also found was that most of these people, slightly more than half, are not being diverted to the community. They're not being released and given community service, probation, supervision, electronic monitoring, whatever. Most of them, the alternative sentence that they're getting is jail and not prison. Now, they're serving less time off, on average at least, in jail than they would have in prison. But it's not like these are community alternatives. It's often being incarcerated in a different place. And so that was interesting to learn. So that's even of the people that are getting these alternative sentences. We also surveyed judges across Virginia to ask them what they think of this. Have they heard of this? Do they use it? Why do they use it? The vast majority said they look at this, which is good because it is in the sentencing guidelines. And then there was wide variation between judges in terms of whether they thought it was valuable or not. Some said, yes, it's important to have this data, this information about whether someone's low or high risk. I rely on that. I rely on my own judgment too, but I rely on it. And you can see that in the data. There's some judges that follow the recommendations in this instrument 90-something% of the time. But then there's some judges that follow it 10% of the time. Now, some of those judges were very vocal in their responses to our survey. We also interviewed judges as well and did a qualitative interview study. So we used multiple methods here. Some of the judges said, you look at my bench. You see a gavel there, not a crystal ball. Or one judge just wrote, minority report. And another judge wrote, some judges may think that this is valuable information to inform judicial decision making. I am not one of them. I also don't go to psychics. So the judges were very vocal. But that was a minority of judges. And what was interesting was that what we found was that there's this wide variation between judges. And so what most of the judges were telling us was not that we don't like this, we don't trust it, minority report. They were saying that we'd like to sentence more of these offenders to the community. We think this information is useful. But what we don't have the beds. We don't have the treatment resources. In this rural district, there's just the only place where someone can be and be supervised is jail. They can get some treatment in jail. They can't get it in the community. No mental health treatment in the community. There are just no beds. And we would love to make use of this more. We just can't practically do it in our district. And so what we wanted to see was, I don't have a slide for it, are some of these districts where you see very high rates, like the places where you have a judge following it 85% of the time versus 41% of the time or 7% of the time. is there some correlation between the rates at which people get these community sentences and the resources available? And the state shared with us detailed information about mental health beds, drug treatment beds, and we found a very, very close connection between beds and dollars spent on mental health treatment, drug treatment, and the use of these alternative sentences. So judges weren't making it up. They were reacting to available resources. They're reluctant to just set a person free if they have treatment needs, if those needs aren't going to be addressed. So I think that's an important lesson, that you can't just adopt a quantitative tool and expect everyone to follow it without some structure and without some resources if resources come along with it. Now, what we're also hearing, though, is that there needs to be more training both among judges and the bar. Plenty of lawyers that we had talked to when we said, there are thousands of people eligible for these community sentences. Do you ask for that for your clients? Lawyers said, we've never heard of that. What is that? And we'd say, well, it's in the sentencing guidelines. And they would say, I don't think so. I've never seen that. And we'd hand over a copy of that part of the sentencing guidelines, and they'd say, no, this never comes up. But we hear that here in North Carolina, too. This isn't just a Virginia story. And so there are plenty of districts, like in Durham, where I live now, where there are pretrial services that can provide treatment. They can provide supervision outside of the jail, and they can make recommendations. They do a risk needs assessment. They actually use a version of a Virginia instrument, and they will say, Judge, this person doesn't need to be in jail. They're not a risk. They do have some needs, and we will address those needs, release them to us. And some judges do that, and some judges don't. Some judges, they say, we do cash bail here. I follow the bail schedule. I'm not interested in this, medical stuff. Whereas in other districts, you see a much closer connection where judges seem to be very, collaborative with pretrial services, and they understand what services are provided and when they're valuable and when they are not. And you see a much more coordination between service providers and the courts. That's a good transition to talk about needs. Our second study in this research lab that I've started with colleagues at Duke will be looking at driver's license suspensions in North Carolina. And the Administrative Office of the Courts, the Access to Justice Commission, and Chief Justice Mark Martin shared with us this remarkable data concerning the 1.25 million people in North Carolina that currently have driver's license suspensions. It's just an enormous number of people. It was a big job actually to clean up the data because it's all in this weird text files that are very hard to work with. And the postdoctoral fellow, Will Crozier, just had an awful experience spending much more than a month just putting this data into a usable form. One thing we find is that there are just a lot more suspensions the bigger a county gets, and there are just vast numbers of these suspensions. There are tens and tens of thousands of these suspensions here in Wake County. There are tens of thousands in Durham County, huge numbers in Mecklenburg. There are also vast numbers, though, in rural counties where a non-trivial chunk of the population has a driver's license suspension. Here's a little bit more information in terms of race, in terms of what types. Many of these are for just directly not paying the fine, the ticket, or any additional fines that were levied for not appearing at the first appearance. There's a far larger number, over 800,000 of these, for failure to appear in court. And that raises questions. Well, are those different people than the people who didn't pay the traffic tickets? Or do people not appear in court because they know they can't pay the ticket? What's the point of showing up when I can't pay this $300 ticket or $200 ticket, whatever it is, or can't pay a $100 ticket? Or do people not appear in court because they didn't get the notice and they didn't know they were supposed to appear in court? Or are there other reasons? They didn't appear in court because they're worried that they have an outstanding warrant, the sheriff's going to pick them up, right? There could be other criminal justice reasons why someone is just afraid of going near the courthouse. We don't know. And we need to do more research to find out. There are serious efforts across North Carolina, but different efforts in different jurisdictions, depending on interest, to try to restore driving to people who've lost their licenses. It obviously doesn't help someone to pay their back fines and fees if they can't legally drive, can't legally get to work, and earn income. It's a counterproductive punishment. I think the theory is that this will This will deter people. If they know that they have to pay their tickets, then they'll take traffic enforcement really seriously. And we use this hammer, the driver's license suspension, to make sure people pay their tickets, make sure people show up on court on time. Once you have 1 in 8 people in the population, though, with suspensions, you suspect that the hammer isn't working the way it's intended to. But we plan to survey people who have these suspensions to find out, do they even know they have it? Hard to deter people who don't even know they're subject to something. If they do know, is it that they don't have the funds to pay? Is it that they have transportation issues now and can't get to court? What are the obstacles here? In Durham, and there are other districts that are talking about this, they've started doing mass dismissals of these old cases. And some of these cases go back 15, 20 years. Mass dismissals of these cases to restore people's driver's licenses and to waive these minor cases. But even to do that, if the person's case is dismissed, they still have to show up in person and apply to have their driver's license restored, which means they have to respond to a notice. And if they didn't get the notice in the first place that their driver's license was suspended, they may not get the notice that, okay, now there's an opportunity to get it restored. And so it may take real work in the community, and that's what some of these efforts have been around, to just explain to people what their rights are, that you haven't lost your driver's license forever, that in fact some of these charges are being dismissed. There's an even easier avenue to do it, but it's going to be a real challenge. And what we're seeing is that there are, like you'd expect, very close relationships between the numbers of these suspensions and poverty rates. And especially now we're talking about people in poverty who can't drive legally, although some may not know it, so they may still be driving. It just may be a much longer and harder process, even for places where prosecutors have said, look, let's just dismiss these things. We want people to be able to get around in our community. You can't take public transportation lots of places. This isn't the right punishment for non-payment of minor traffic tickets. So I think I talked about this already. I didn't realize the slides were towards the end. But one thing we say in our work looking at treatment in Virginia is that there's a justice reinvestment model where reducing incarceration can produce real cost savings over time. Maybe not always directly right away, because it's not like, if 1/10 of the jail is empty, that saves 1/10 of the costs. You still need to man the jail and have heat and electricity in it. Maybe only once you close a wing or something like that can you really realize some cash savings. But the idea behind this justice reinvestment model is to use some of these evidence-informed approaches to think about less expensive ways to treat offenders, ways that aren't counterproductive, ways that can include treatment to help make the person not someone who would violate the law again in the future, and then invest those savings in kind of a virtuous circle of doubling down on that treatment to lower crime in the future. Now, North Carolina passed a Justice Reinvestment Act in 2011, and there have been some real successes under that act. The focus, though, was on probation. Now, before 2011, it had gotten to the point where half of all prison admissions in North Carolina were for probation violations. And it could be, small technical violations could land you back in prison. That was an enormous amount of the prison population, enormously expensive. Remarkable strides have been made in providing probation officers with more discretion and other avenues so that you're not sending someone back to prison every time there's a minor, you're not showing up for an appointment with a probation officer, maybe because you lost your driver's license, I don't know. But there hasn't been the same focus as in other states on thinking about justice reinvestment, not just in probation, but in other aspects of the system. It is something, though, that more districts in Virginia are thinking about doing. And my team and I have been talking to both prosecutors and courts about, how do we make it more feasible for people to appear in court so you don't get hit with these failure to appears, loss of driver's licenses? Can we arrange transportation? Can we make our system for dockets more flexible so that it's easier to reschedule things? Can we do diversion at the point of arrest? There's an enormous interest. The Attorney General just held a huge summit for law enforcement-assisted diversion to think about identifying people who are opioid addicts and at risk at the point of arrest. And rather than send them straight to jail for some minor crime where they could suffer an overdose and the cost could be terrible, including cost to life, can we think about connecting them with with addiction treatment providers right away because it could be an emergency situation, and training officers on how you even identify that. Sheriffs from around the state were talking about what are some of the best practices for doing that, given that we do have an opioid epidemic, and police are often the first point of contact. But also diversion that prosecutors can do, not at the point of arrest, but thinking about, well, maybe we don't need to wait till someone's being sentenced to say this is a low-risk offender, let's think about what the alternative sentence is. Maybe there are some charges that you can divert to community treatment, community programs early on in the process. One mechanism has often been called a deferred prosecution agreement, where you say, okay, if you comply with the terms of this agreement over the course of the next year or year and a half, whatever the time period is, then the charges will be dismissed from the docket. You won't have a criminal record. And then there won't be those other employment and other consequences of having a record, but there will be an extended period of time during which someone will be watched, supervised, and the idea is that performs some of the functions of probation, but on the front end. And so one goal is that we as researchers should be there to collect data and find out whether these programs are working or whether they're not. If they are working, can they be expanded in a way that gains the same benefits as what was piloted initially? Or if there are parts of a program that aren't working, then they should stop. And whether it's a court clerk's office or a prosecutor's office, we're working with the Houston Crime Lab with their fingerprinting unit and soon to be some of the other disciplines in the lab. Whether it's a crime lab or a prosecutor or a clerk's office, they don't have researchers in-house typically. It's not something that it was typically their job. Large organizations absolutely have compliance officers, and they collect evidence and they do risk analyses, and that's part of their business model. But in government and the criminal justice system, there haven't been the resources for that, and there still often aren't. But the hope is that as researchers, we can provide a partner to agencies that are interested in studying themselves and learning what they could do better. And so those are the types of projects that we're working on. We're working on some others. I'd love to hear your thoughts on some of these research projects, some of these larger goals that we have. And I'm looking forward to getting to know some of you and learning more about the work of the Locke Foundation as well. Thank you so much again for having me.
All right, questions and comments. I will start then. Professor, regarding the issue of people who have been convicted and then found to not have committed the crime.
Yeah.
Really, how can you compare North Carolina and unfortunately the prevalence, at least that we know of at this point, compared to other states? Would you classify North Carolina as a problem state, so to speak, or do we not know yet?
I think there have been a number of high-profile exonerations in North Carolina, but there have been in almost every state in the United States. And there have been exonerations in death penalty cases, in other serious cases. Like in many states, though, traditionally, for example, forensic evidence, sexual assault kits and the like, in many districts weren't preserved. And so, we don't know how many old cases could be tested but haven't been, for example. The response in North Carolina, though, for many years, North Carolina was really a leader in terms of responding to these concerns about wrongful convictions. So former Chief Justice Beverly Lake founded a study commission, which for several years made a whole series of recommendations that led to legislation. So North Carolina was really a pioneering state on a number of topics. So North Carolina was one of the first states, maybe the first state, maybe it tied with Ohio, to pass statewide legislation saying you need to do lineups for eyewitness identifications blind, so that the officers aren't saying, so is it this guy? Just taking the officer out of the equation and let the person just do a memory test without suggestions from the officer. North Carolina took the lead in having best practices just through legislation statewide. North Carolina also took the lead in requiring videotaping of interrogations. We didn't talk a lot about false confessions today, but there have been troubling false confessions in lots of different states. I don't think anyone really realized that even without torture, even without the third degree, just after a grueling questioning over many, many hours, innocent people can be worn down and confess to things that they didn't do. So one of the main protections is to videotape the whole proceeding so there's a record. North Carolina took the lead on that. North Carolina also was one of the first states to pass an open file discovery law, including in response to the Duke Lacrosse case, and some prosecutorial misconduct scandals. I think there was like multiple district attorneys in Durham that ran afoul of the ethics rules. I think when our new district attorney was sworn in, the chief judge in Durham said, I've seen some of the best district attorneys in the state and some of the worst. And really, when I say some of the worst, I mean, and so, North Carolina has learned some lessons through serious mistakes. And North Carolina is also the only state in the country that has an actual innocence inquiry commission, where there's an actual government body that can do investigations and reopen old cases, find the evidence, and make recommendations to the courts. And that's how several of the exonerations have happened, because we're the only state in the country that has a government body whose job it is to try to seek out wrongful convictions. So there's a lot that North Carolina has to be proud of. There have also been problems in the past with the state crime lab, and there have been reforms adopted in response to that. But that's one of many crime labs in the state. There are lots of questions about how forensic evidence is used. As a researcher, I'm interested in how well agencies are following some of the laws that are on the books as to lineups, as to interrogations. Videotaping interrogations doesn't change what methods are used when you interrogate someone. There's also the question of what happens when plea bargaining occurs in any state. Lawyers may not even be carefully looking at the forensics reports or what did the guy say during the interrogation during plea bargaining. There's often not a lot of information shared between the parties. Prosecutors may themselves be somewhat in the dark. They're just trying to get cases off their docket. They've only had the case for a few weeks. And plea bargaining is highly informal. It means that we don't know a lot about what happens during that process or what the risks are for error. And so I think there are a lot of the criminal justice system is a black box, and it's really hard to say, like, do innocent people still get convicted? How many? And what types of cases? What types of crimes? For a lot of crimes, we just have no idea.
Corey?
The John Locke Foundation initiated in the process of recodification of the North Carolina criminal code, worked with Chief Justice Martin, among others, Justice Smith at UNC, and so on down the line. Can you talk about the intersection between recodification and evidentiary rules? Does recodification have implications for that?
Well, yes and no. So, I mean, there can be elements of crimes which raise questions of proof and the reliability of proof. But for the most part, no. You're dealing with perhaps uneven definitions about intent in criminal law, and so the recodification can do lots of things to help to make the criminal code better organized, to rethink whether things still deserve to be crimes at different levels, making crimes consistent across each other. That said, there are a lot of obscure crimes which, in different recodification efforts, people have gotten off the books. Like, why do we still have an offense for making fun of the image of Smokey the Bear or whatever? But those aren't cases that are charged very much. The bread and butter of what police are arresting people and charging them for are a relatively smaller group of offenses where the offense itself doesn't raise difficulties of proof. That said, as part of the recodification effort, I'm sure you're going to come across crimes where their definitions are vague, and there really will be questions about whether people could be convicted of things that they didn't intend as wrongs. Certainly in the federal statutes, there are lots of concerns about intent standards that are hard to understand, and so there's the concern that people didn't have a bad state of mind when they commit the crime. I don't know enough about North Carolina law either to know whether there are offenses that raise some of those same questions. But a lot of these questions about evidence apply to any crime, no matter what the definition. If you have a faulty forensic test, you can link someone to, any number of different offenses, including offenses like a murder, which are really clear and well defined.
Professor, I just read recently where there's a very large number of incarcerated individuals that are just waiting for trial. So, I mean, it's a very tremendous burden on our society to have these people in jail, and we don't have any idea yet whether they're guilty or not. Certainly not proven guilty.
Yeah.
Maybe this has to go all the way down to the police force to begin to determine whether people should be incarcerated or should.
Well, police make a decision whether to arrest or not, and so there have been efforts, and there's some rural districts that Jesse Smith at UNC has been working with that are rethinking. Okay, do we really need to hold this person potentially in jail for many, many months before a trial? Since in many districts there really are long delays. You hear about people waiting 2 years for a trial or more. And for some people, they're dangerous enough that, okay, no, we don't want that person in the community for that year or 2 years. But what some rural districts have started to implement is a system where for certain crimes, we just give them a citation to come back into court. For a basic traffic offense, you don't put the person in jail to make sure that they're there to pay their traffic ticket. We figure this is an offense that's not sufficiently dangerous to put the person in jail. You let them out, and if they don't show up, you issue a warrant and find them then. And so you can expand the number of offenses where police don't automatically jail at the point of arrest. So that's one approach. The second approach is for prosecutors to rethink, are we going to seek jail time for all of these people? Are we comfortable with this person being supervised in the community pending this trial date? There's enormous pressure on people to plead guilty just to get out of jail because they may serve more time in jail waiting for their trial date than they would have if they got convicted. There was just a case I was looking at where there were real questions about the fingerprint evidence. And I was kind of hoping there would be a trial because I thought that there were real questions about the fingerprint evidence. But the person had already served all but 2 months of what they would get convicted of if they get convicted at trial. And so from that person's perspective, it's like, well, I can save 2 months and plead guilty now. And I don't know what's going to happen at the trial, and I've already been in jail forever. I want to get out. And it's understandable. And that's not as big a trial penalty as some people have. That was just getting out 2 months early. I was kind of shocked to hear, and I understand it doesn't always work in necessarily a troubling way, but I never heard of a state where district attorneys control the calendar formally in courts. Judges don't have full control over their own calendars. It sounds like in practice lots of district attorneys wisely defer to judges on many calendaring questions. But the backlogs are remarkable, especially considering how few, what a tiny percentage of felony cases actually go to a trial. Now, what some jurisdictions are also doing is rethinking cash bail as a mechanism for deciding who is in jail waiting for their trial and who isn't. Right? It shouldn't depend on your ability to pay. Right? Bail should be set at a level which hurts enough that you will come back because you don't want to lose that money, but you're not in jail because you just simply could never conceivably come up with $200. And so the person with $200 is in the community, and the person without $200 is in jail for 8 months. Right? That's not a system that makes sense. It shouldn't be constitutional. And there's been serious litigation around the due process and excessive bail clause and other implications of having a system where your financial resources decide whether you're in jail or not. I have no doubt that there will be litigation over that issue in the years ahead in North Carolina like there has been in other states.
We have time for one more question.
Really just a comment. One of the problems, the reasons you have the sort of sentence first, conviction later in this state is there is no Speedy Trial Act in the state of North Carolina. So there's no impetus to move the case along. Only place I know that's like that. I mean, I previously practiced as a prosecutor in New York State and a federal prosecutor here. And you always have the clock on it. There's no clock in North Carolina.
You do. I mean, the clock gets waived and told for lots of different reasons. It's not like a speedy trial.
There's no clock.
Right. I mean, it's not like the clock solves all these problems, but it's good to have a clock.
Well, because if there is a clock, there's a way that you can get relief.
Right.
Professor
Yeah, thank you.